Hi, my name is attorney Wendy Guthro, a licensed attorney in both Massachusetts and New Hampshire, and I am here to discuss the probate process in Massachusetts, why you should consider avoiding it, and techniques to avoid it. I'm going to start a slideshow presentation so we can just get into the details of the probate process in Massachusetts. So this webinar will be about 30 minutes, possibly less than that. There'll be time for questions and answers afterwards. If you're listening to this after the presentation, that was done on July 20th, 2023, then you can always contact us directly and ask us any questions at our email address of admin@guthrolaw.com. So today it's understanding the probate process in Massachusetts, avoiding probate, which allows you to maintain control and keep your privacy using revocable trusts. A little bit about myself. I am a licensed attorney in New Hampshire, Massachusetts, as I stated. I do estate planning, elder law, probate, and trust administration. I am a member of the National Academy of Elder Law Attorneys. And as I said earlier, I'm admitted in both Massachusetts and New Hampshire on the state and the federal bars. The objective of this webinar is to explain to you exactly what probate is, the probate process as it is in Massachusetts, because it varies from state to state, reasons to avoid probate, and how to avoid probate using trusts. What is probate? Probate is retitling assets into a new owner's name after the original owner passes away. It involves the role of the probate court, the probate process within Massachusetts, and I'm going to also discuss the potential challenges and delays in probate. But specifically, the definition of probate is retitling assets into a new owner's name after the original owner dies when you are unable to ascertain who legally is the new owner of that particular asset. To do so, you would normally need to open up probate in the probate court, submit documents, a will if you have it, and then get that approved by the court. Probate process within Massachusetts. As I said, every state has their own laws regarding how assets will be probated upon someone's passing. Today, we will speak specifically regarding the Massachusetts process. So to start probate, which as I said earlier, it is simply when someone passes away, whether the assets need to be retitled into a new owner's name, we're going to file the will with the probate court, if there is a will. So whether there's a will or no will, it's a very similar process. The probate process begins with the filing of the deceased person's will with the probate court in whatever county that person resided in at the time of their death. So if they're in Burlington, it's Middlesex County. We would use the Middlesex County probate courts to open up probate of the decedent. The next thing we're going to do is appoint a personal representative, which was previously referred to as an executor and executrix. The court reviews the will, and if you have appointed someone in the will to be your personal representative, and there isn't any impediment for that person to serve, then they will serve as your personal representative. If there is no will, the court will appoint a personal representative based upon the state law. So normally if there's a surviving spouse, they would have first priority. If there is no surviving spouse, then any one of your children would have priority to open probate and be appointed your personal representative. The probate process, the next step of the probate process is to conduct an inventory. The personal representative that I'll refer to as the PR moving forward is responsible for notifying creditors, paying off outstanding debts, and settling any tax obligations of the deceased person's estate. This may involve selling assets if necessary to pay debts or a tax burden. The personal representative obtains a tax identification number for the estate and or the trust and establishes an estate bank account. So really what we're doing here is corralling all the assets together of the decedent, putting it on an inventory list that we're going to provide to the court and eventually all of the beneficiaries. And then once we have done that, we're going to also corral together all of the debts and figure out whether there is an estate tax obligation to pay or other personal or fiduciary tax returns that need to be filed after someone passes away. The next step is we're going to, well, before this, as I said on the previous slide, we then have to set up an estate bank account that's then going to receive the assets. And then once the estate bank account receives the assets of the decedent, then we have money in a bank account that we will then use to pay for the debts of the decedent. So the personal representative first identifies and creates the inventory of the deceased person's assets, including real estate, bank accounts, investment accounts, personal property, and any other asset owned by the decedent, whether it has a title or not, such as vehicles, boats, airplanes. Next, after we've paid the debts and the taxes, the remaining assets are then distributed among the beneficiaries according to the terms outlined in the will. If there is no will, the assets are distributed according to state intestacy law. So if you meet with our firm and then we outlined who you would like to receive your assets upon your passing, or conversely, who you might want to disinherit, we would then memorialize that information into your will. And then upon your passing, we're submitting that will into the probate court. And then after we have done all the previous steps, we would then be able to set up a distribution scheme for the remaining assets to the named beneficiaries. There is probate court supervision throughout the probate process. So throughout the process, the court oversees the personal representative's actions. They review all of the filings that are submitted and ensure that the estate is handled properly. The court may also resolve any disputes or challenges to the will, remove a personal representative, or add another one if someone passes away. So because of this court supervision, it becomes a very tedious and lengthy process with a lot of oversight. There are some instances where you want this oversight, but for the majority of my clients, we are not looking to get any court supervision if it's not really needed. After we have done all the previous steps, now we would like to close probate. So this is the completion of probate. So after 1 year, and once all debts are settled, taxes are paid, and the assets are distributed to the beneficiaries, the personal representative files a final accounting with the court. A copy of that accounting will also be provided to all of the beneficiaries before they receive their distribution. After the court's approval of the accounting, the probate process is considered complete, and the personal representative will no longer, after a period of time, have liability as personal representative of the estate. So that, in summary, is the probate process within Massachusetts. It seems like a very short-tiered system and step-by-step, but there isn't any way that that process can take place in any less time than 1 year. It's not unusual for probates to go much longer than that and incur a significant expense. So I'd like to speak to you about reasons to avoid probate. So the probate process in Massachusetts is time-consuming. As I stated, it takes a minimum of 1 year. If it's a contested or a complex estate, it will take years to settle. Court, accounting, attorney fees, and tax filings, and any tax liability due, add considerable cost to probating someone's estate. The probate process is public process, so there is no privacy. So anyone does have the availability of looking at your will and determining who you named as your beneficiaries and who are the beneficiaries of your estate. If there is no will, the state decides who will get your assets, versus if you have named people in a will, then those people will receive those assets. But regardless, it is a public process and not a private affair. So, but for me, I think one, the cost associated with probate, the length of time associated with it, and the complexities with it make it worth trying to avoid. So those factors mentioned make it worthwhile to consider alternatives, such as using a trust to avoid probate. Keeps matters private, and it streamlines the distribution of assets upon your death or the decedent's death. So how can you avoid probate using trusts? Well, to get into trust, I'd first like to just show you the overview of estate planning documents. I suggest all of my clients have a will, even though our goal is to not really ever use the will. And then to have a trust, revocable and or irrevocable trust, to have a power of attorney that's used during your lifetime so someone can handle your finances upon your passing, and 3 healthcare documents: your healthcare proxy, for someone to make medical decisions for you based upon your desires, and only upon your incapacity. A HIPAA, who has access to your protected healthcare information, and a living will, whether you would like to be kept alive on life support or not if death is imminent. So all of these documents would be encompassed in a complete estate plan. So what is a trust? If I'm purporting that a trust is one of the main vehicles that you could use to avoid probate, a trust is a legal entity that can hold your assets during your lifetime and distribute them after your death without using the probate court system. So here is a container named a trust, and I put it in this format because it's truly a container to hold things. So what I want you to do is consider to create a trust to hold your assets, because anything that we get into this container during your lifetime, we will avoid probate upon your death. In a trust, there are 3 roles: the grantor, the trustee, and the beneficiary. The grantor, usually you, is the person who creates the trust and transfers their assets into the trust. The trustee, on the other hand, is the person in charge of following the trust instructions. So if we were to meet and we decide on what type of trust you would like and the details of the trust, who you'd like to be in a fiduciary capacity, who would you like to be the trustee, who you'd like to be the beneficiaries, the trustee has to follow those instructions that you have memorialized. The trustee manages the trust for the benefit of the beneficiaries. Well, who are the beneficiaries? The beneficiaries are usually you during your lifetime, and then your heirs upon your passing. Some people name other people or charities who will benefit from your trust, but normally your heirs at law or your heirs that you select, normally your children or grandchildren or close friends. What is the difference between a will or a trust? Well, a will we've been speaking about because that is the vehicle you use to open up probate. So it's a legal document that distributes your assets after your death to the next owner using the probate court system. Versus a trust, whether it's revocable or irrevocable, is a legal entity that can hold your assets during your lifetime and distribute them after your death without using the probate court system. So this graphic shows the 2 differences of the will is going to open up the probate system and the trust is going to be a non-probate asset, and we will not engage in the probate system, but we will engage in estate administration. Another graphic to show, if we're going to use probate, we're going to use your will, we're going to bring it to the probate court, we're going to then have the court oversee the distribution of your assets to your named beneficiaries. Normally a costly process. It takes at least 1 year. It's public, and there's no asset protection strategies enabled in the probate system when you use your will. Versus if you decide to do probate avoidance planning, you would use a trust. You would appoint your trustee, very peaceful, and this peaceful trustee, hopefully peaceful, will then distribute your assets to the named beneficiaries. It's immediate. It can normally take place within weeks after your death. It's a private matter because the trust is not recorded at the probate court, and that it can offer some asset protection planning if you have done a particular type of trust, or some tax planning if you've done tax planning trust for married couples. So to avoid probate using trust, we create the trust, and then we're going to transfer assets into a trust to avoid probate. So we normally take care of transferring the deed to your home into your trust. Your bank accounts, we give you funding instructions of how you'll get your assets, your bank accounts transferred into the trust. Stock, bond, and investment accounts can also be transferred into your trust. So if you fund your trust during your lifetime, it will avoid probate. Trust can be revocable or irrevocable, and the trust and estate planning accomplish many goals, as I have stated. One, what this webinar is all about is really probate avoidance. So that's one very large, compelling reason to create a trust and fund it. Asset protection trusts, we use those for irrevocable trusts, oftentimes for Medicaid planning. Then we also want trust to control and management of assets in a systemized way. We want to sometimes minimize estate taxes for married couples. And we also use trust for special needs and disabled individual planning for them, so that if they're on public benefits, we don't disturb their public benefits. So now that we have trust created and we reviewed some of those things, I'd like to go into some examples and case studies so that you can fully understand some of the things that I've just discussed. So our first case study is Harry and Wilma, husband and wife, are married with 3 children. Harry dies with a will. His assets that he has a $25,000 IRA. Wilma is named the beneficiary. $50,000 individual titled bank account in his name alone. He has a joint bank account with Wilma, and he has term life insurance and named beneficiary as Wilma. They also have a $750,000 house that's jointly titled with Wilma. When Harry dies, will any of his assets need to be probated? So let's take a look at that. So we have these assets that are all named, and so the $750,000 house jointly titled with his wife, Wilma. So the question is, when Harry dies, will any of his assets need to be probated? The answer is that the $50,000 individually titled bank account will need to be probated because no one is named a beneficiary. The next case study is that Harry dies, then Wilma dies 2 months later with a will as well. Wilma took the $25,000 inherited IRA from Harry, but she didn't get a chance to name a beneficiary. She also has a $50,000 jointly titled bank account with her son that she had added him to the account after Harry died. And then she had a joint bank account with Harry, and she still has her house jointly titled with Harry. When Wilma dies, will any of her assets be probated? Yes. The inherited IRA with no named beneficiary will have to go to the probate court. Her joint bank account that she held with Harry, as well as the jointly titled house, will have to be probated. So most of Wilma's assets will need to be probated. The non-probate assets will go to her son, which is the jointly titled bank account, whose name was on that account, and he is under no legal obligation to share that account with any of his siblings. The third case study is conversely that now Harry and Wilma are married still. They have a trust naming themselves as the grantor, trustees, and beneficiaries. There's successor trustees and beneficiaries named, and it's their children and or grandchildren. And all of their assets have been transferred into trust or name the trust as the beneficiary. So if we take a look at this, the individual and joint assets that are held in trust, all of these assets are held. We have to go to probate on either one of their deaths. the answer is no, that all of these assets that are held in trust will avoid probate. So if you have any questions, you're welcome to email them to us or contact our office. The main reasons why you should consider a trust is that it avoids probate. It's private and immediate. You can plan for disability now or later if for yourself, and know that your affairs are going to be taken care of. If you are over $1 million in Massachusetts, and married, you can do a tax trust to help eliminate or reduce your Massachusetts state tax. And if you do irrevocable trust planning, we can also do Medicaid planning and start the 5-year look back period. So I'm open to take questions. But as I said, if you're listening to this later on, then you can contact us directly at admin@guthrolaw.com. As I said, you're welcome to call us. Thank you very much. I hope you have found this Probate in Massachusetts seminar helpful. Thank you.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.